CLEP Introductory Business Law Practice Exam. Question 1. Contracts usually become enforceable only after which element joins offer and acceptance? Option A, consideration. Option B, duress. Option C, discovery. Option D, venue. The correct answer is option A. Consideration. Consideration is the bargain for exchange that supports most contracts. Duress is an improper pressure defense, discovery is a litigation process, and venue concerns where a case is heard. Question 2. Merchants under Article 2 of the UCC mainly deal with which type of transaction? Option A, sales of goods. Option B, employment contracts. Option C, personal injury claims. Option D, real estate leases. The correct answer is option A. Sales of goods. Article 2 of the UCC primarily governs sales of goods. Real estate leases, employment contracts, and personal injury claims are governed by other bodies of law. Question 3. Offerors can normally revoke an ordinary offer before which event occurs? Option A. The offeree accepts it. Option B. The mailbox rule is printed. Option C. The offeree rejects it. Option D. A court files it. The correct answer is option A. The offeree accepts it. An ordinary offer can generally be revoked before valid acceptance. Rejection already ends the offer, court filing is not required, and the mailbox rule concerns timing rather than printing. Question 4. Acceptance becomes effective under the mailbox rule at what point? Option A. When consideration is returned. Option B. When it is properly dispatched. Option C. When the offerer reads it. Option D. When a judge approves it. The correct answer is option B. When it is properly dispatched. Under the mailbox rule, acceptance is usually effective when properly sent. Reading by the offerer is not required, judges do not approve ordinary acceptances, and consideration is not something returned for timing. Question 5. Consideration fails when a promise is based only on which situation? Option A. A new legal duty. Option B, past performance already completed. Option C, mutual promises exchanged now. Option D. A requested act by the promisee. The correct answer is option B. Past performance already completed. Past consideration usually does not support a new contract because it was not bargained for now. A new legal duty, current mutual promises, and requested acts can supply valid consideration. Question 6. Minors generally have which power when they enter most contracts? Option A, power to prosecute. Option B, power to notarize. Option C, power to condemn property. Option D, power to disaffirm. The correct answer is option D. Power to disaffirm. Minors generally may disaffirm many contracts to protect them from improvident bargains. Prosecution, notarization, and condemnation are unrelated governmental or formal acts. Question 7. Legality makes a contract unenforceable when the agreement requires what? Option A. An illegal act. Option B. A low purchase price. Option C. A written signature. Option D. A risky business plan. The correct answer is option A. An illegal act. A contract requiring an illegal act is generally unenforceable. A signature, business risk, or low price does not by itself make the agreement illegal. Question 8. Capacity is most likely questioned when a party lacked what at formation? Option A. A marketing plan. Option B, mental ability to understand. Option C. A business logo. Option D. A bank account. The correct answer is option B. Mental ability to understand. Capacity concerns whether a person had the legal and mental ability to contract. A logo, bank account, or marketing plan may be useful in business but does not determine capacity. Question 9. Fraud in contract law usually requires a false statement plus what additional feature? Option A. A notarized seal. Option B. Intent to induce reliance. Option C. A public hearing. Option D. A trademark filing. The correct answer is option B. Intent to induce reliance. Fraud commonly requires a material misrepresentation made with intent to induce reliance. Notarization, public hearings, and trademark filings are not core fraud elements. Question 10. Duress gives a party a defense when assent was obtained through what? Option A. Accurate market information. Option B. Prompt delivery. Option C. A standard warranty. Option D. Unfair persuasion or threat. The correct answer is option D. Unfair persuasion or threat. Duress involves improper threats or coercion that undermine voluntary agreement. Accurate information, prompt performance, and warranties do not show coerced assent. Question 11. Mistake may allow avoidance when both parties are wrong about which type of fact? Option A. A social media comment. Option B. A court schedule. Option C. A material fact. Option D. A trivial spelling choice. The correct answer is option C. A material fact. A mutual mistake about a material fact can make a contract voidable. Minor spelling choices, online comments, and court schedules usually are not material facts in the bargain. Question 12. Statute of frauds rules most often require certain contracts to be in what form? Option A. Video form. Option B. Oral only. Option C. Written form. Option D. Secret form. The correct answer is option C. Written form. The statute of frauds requires specified agreements to be evidenced by writing. Oral only, secret, or video only forms do not satisfy the general writing requirement by themselves. Question 13. Land sale agreements usually fall under which contract writing requirement? Option A. Parole evidence rule. Option B. Statute of frauds. Option C. Residential ipsa loquitur. Option D. Strict liability. The correct answer is option B. Statute of frauds. Contracts for the sale of land generally must satisfy the statute of frauds. The parole evidence rule concerns prior statements, while residential ipsa loquitur and strict liability are tort concepts. Question 14. Parole evidence mainly limits the use of what kind of proof? Option A. Prior or contemporaneous oral terms. Option B. Physical fingerprints. Option C. Statutory citations. Option D. Later tax returns. The correct answer is option A. Prior or contemporaneous oral terms. The parole evidence rule can bar prior or contemporaneous oral terms that contradict an integrated writing. Tax returns, fingerprints, and statutes are not the usual target of the rule. Question 15. Breach occurs when a party does what to a contractual duty? Option A. Negotiates before signing. Option B. Names a beneficiary. Option C. Fails to perform it. Option D. Reads it carefully. The correct answer is option C. Fails to perform it. A breach is a failure to perform a contractual duty without legal excuse. Reading, negotiating, and naming a beneficiary do not by themselves violate a duty. Question 16. Damages in contract cases are usually designed to put the injured party where? Option A. Above all competitors. Option B. In the expected bargain position. Option C. In jail. Option D. On a jury. The correct answer is option B. In the expected bargain position. Expectation damages aim to give the injured party the benefit of the bargain. Jail is criminal punishment, jury service is procedural, and competitive advantage is not the goal. Question 17. Specific performance is most likely ordered when money damages are inadequate for what? Option A, unique goods or land. Option B, common office supplies. Option C, minor clerical errors. Option D, routine advertising. The correct answer is option A. Unique goods or land. Specific performance is used when the subject matter is unique, such as land or rare goods. Common supplies, clerical errors, and routine advertising can usually be addressed with money damages. Question 18. Liquidated damages clauses are most enforceable when the amount is what? Option A. A hidden penalty. Option B, whatever scares the buyer. Option C, always zero. Option D. A reasonable forecast of loss. The correct answer is option D. A reasonable forecast of loss. Liquidated damages are enforceable when they reasonably estimate likely loss and damages are difficult to measure. Hidden penalties, intimidation, and automatic zero damages are not proper standards. Question 19. Rescission primarily cancels a contract and does what to the parties? Option A, creates a corporation. Option B, transfers a patent. Option C, returns them to pre-contract positions. Option D, sends them to prison. The correct answer is option C. Returns them to pre-contract positions. Rescission cancels the contract and attempts to restore the parties to their prior positions. Prison, incorporation, and patent transfers are separate legal matters. Question 20. Novation substitutes a new party and requires what from the original parties? Option A. A patent search. Option B, consent. Option C. A criminal trial. Option D. A tax audit. The correct answer is option B. Consent. Novation requires agreement to replace an old party with a new one and release the old party. Criminal trials, tax audits, and patent searches are unrelated to novation. Question 21. Assignment transfers contractual rights, while delegation transfers what? Option A, duties. Option B, courtrooms. Option C, jurors. Option D, statutes. The correct answer is option A. Duties. An assignment transfers rights, and a delegation transfers performance duties. Courtrooms, jurors, and statutes are part of the legal system rather than contract performance. Question 22. Third-party beneficiaries may sue on a contract when the contract intended what? Option A. To exclude all outsiders. Option B. To create a crime. Option C. To avoid all duties. Option D. To benefit them. The correct answer is option D. To benefit them. Intended third-party beneficiaries can enforce a contract made for their benefit. Incidental outsiders, criminal plans, and duty avoidance do not create beneficiary enforcement rights. Question 23. Promissory estoppel can enforce a promise when reliance was what? Option A, purely criminal. Option B. Only sarcastic. Option C, reasonable and foreseeable. Option D, hidden and impossible. The correct answer is option C. Reasonable and foreseeable. Promissory estoppel protects reasonable, foreseeable reliance on a promise when injustice would otherwise result. Hidden, impossible, criminal, or sarcastic conduct does not satisfy the doctrine. Question 24. Common law mainly develops through which source? Option A, product labels. Option B, judicial decisions. Option C, sales invoices. Option D, private rumors. The correct answer is option B. Judicial decisions. Common law is built through court decisions and precedent. Invoices, rumors, and labels may be evidence in some situations but are not the source of common law. Question 25. Precedent guides later courts through which principle? Option A, stare decisis. Option B, caveat emptor. Option C, voir dire. Option D, quantum meruit. The correct answer is option A. Stare decisis. Stare decisis means courts generally follow prior relevant decisions. Caveat emptor concerns buyer caution, voir dire concerns jury selection, and quantum meruit concerns reasonable value recovery. Question 26. Constitutions outrank ordinary statutes because they serve as what? Option A, optional business advice. Option B, private contract language. Option C, a court transcript. Option D, supreme foundational law. The correct answer is option D. Supreme foundational law. A constitution is foundational law and controls inconsistent ordinary statutes. Business advice, contract language, and transcripts do not have the same legal supremacy. Question 27. Statutes are laws primarily created by which body? Option A, auditors. Option B, newspapers. Option C, legislatures. Option D, juries. The correct answer is option C. Legislatures. Statutes are enacted by legislative bodies. Juries find facts, auditors review records, and newspapers report information rather than make statutes. Question 28. Regulations are usually issued by which type of authority? Option A, trial witnesses. Option B, administrative agencies. Option C, private landlords. Option D, random consumers. The correct answer is option B. Administrative agencies. Administrative agencies issue regulations under authority granted by statutes. Landlords, consumers, and witnesses do not generally create binding public regulations. Question 29. Jurisdiction asks whether a court has what over a case or party. Option A, legal authority. Option B, marketing interest. Option C, accounting profit. Option D, personal friendship. The correct answer is option A. Legal authority. Jurisdiction is the legal power to hear a case or bind a party. Marketing interest, profit, and friendship do not establish court authority. Question 30. Venue focuses on which practical issue in litigation? Option A, correct contract price. Option B, best advertising slogan. Option C, amount of inventory. Option D, proper geographic location. The correct answer is option D. Proper geographic location. Venue concerns the proper geographic place for trial within a court system. Contract price, advertising, and inventory are business matters rather than venue questions. Question 31. Pleadings usually begin a civil lawsuit by doing what? Option A, delivering all products. Option B, paying punitive damages. Option C, stating claims and defenses. Option D, selecting a trademark color. The correct answer is option C. Stating claims and defenses. Pleadings set out the plaintiff's claims and the defendant's responses or defenses. Trademark colors, product delivery, and punitive damages are not the initial pleading function. Question 32. Discovery allows parties to obtain what before trial? Option A, a secret verdict. Option B, relevant information. Option C, guaranteed victory. Option D, a criminal pardon. The correct answer is option B, relevant information. Discovery helps parties gather relevant information from each other before trial. It does not guarantee victory, grant pardons, or produce secret verdicts. Question 33. Mediation differs from arbitration because the mediator usually does what? Option A, facilitates settlement without imposing a decision. Option B, issues a binding award automatically. Option C, files criminal charges. Option D, serves as a juror. The correct answer is option A. Facilitates settlement without imposing a decision. Mediation uses a neutral person to help parties negotiate, usually without imposing a result. Arbitration may produce an award, while criminal charging and jury service are different roles. Question 34. Arbitration most closely resembles a private version of what process? Option A, advertising. Option B, bookkeeping. Option C, licensing. Option D, adjudication. The correct answer is option D. Adjudication. Arbitration is a private dispute resolution process where a neutral hears evidence and decides. Advertising, bookkeeping, and licensing do not describe this adjudicative function. Question 35. Civil cases generally require proof by which standard? Option A, probable rumor. Option B, unanimous advertisement. Option C, preponderance of the evidence. Option D, beyond all possible doubt. The correct answer is option C. Preponderance of the evidence. Most civil cases use the preponderance standard, meaning more likely than not. Beyond all possible doubt is not the criminal standard, and rumor or advertising are not legal proof standards. Question 36. Criminal convictions generally require proof beyond what level? Option A. A contract offer. Option B. A reasonable doubt. Option C. A business preference. Option D. A simple invoice. The correct answer is option B. A reasonable doubt. Criminal cases generally require proof beyond a reasonable doubt. Business preferences, invoices, and offers do not state the constitutional burden of proof. Question 37. Plaintiffs in civil cases are the parties who usually do what? Option A, bring the lawsuit. Option B, hear the evidence as jurors. Option C, issue agency rules. Option D, approve corporate bylaws. The correct answer is option A. Bring the lawsuit. A plaintiff initiates a civil lawsuit. Jurors hear evidence, agencies issue regulations, and corporations approve bylaws through internal governance. Question 38. Defendants are the parties who are typically what in a lawsuit? Option A, always victorious. Option B, automatically judges. Option C, never represented. Option D, sued or accused. The correct answer is option D. Sued or accused. A defendant is the party sued in civil court or accused in criminal court. Defendants are not automatically winners, judges, or unrepresented parties. Question 39. Appeals usually review alleged errors made by which level? Option A, sales department. Option B, human resources desk. Option C, trial court. Option D, accounting office. The correct answer is option C. Trial court. Appeals focus on claimed legal errors from the trial court. Accounting, sales, and human resources may create facts but are not appellate review levels. Question 40. Commerce Clause power lets Congress regulate what type of activity? Option A, personal diary entries. Option B, interstate commerce. Option C, private family dinners. Option D, purely local hobbies with no commerce. The correct answer is option B. Interstate commerce. The Commerce Clause supports federal regulation of interstate commerce. Private dinners, non-commercial local hobbies, and diary entries are not the core target of that power. Question 41. Supremacy Clause conflicts are resolved by giving priority to what? Option A, valid federal law. Option B, any local custom. Option C. Every private memo. Option D. A business slogan. The correct answer is option A. Valid federal law. The Supremacy Clause makes valid federal law superior to conflicting state law. Local custom, private memos, and slogans do not override federal law. Question 42. Due process protects people from government action without what? Option A. Company profit. Option B. Advertising space. Option C. Contract discounts. Option D. Fair procedures. The correct answer is option D. Fair procedures. Due process requires fair procedures and, in some contexts, substantive fairness. Profit, advertising, and discounts are not due process guarantees. Question 43. Equal protection challenges focus on unfair government treatment among whom? Option A. Only judges. Option B. Only landlords. Option C. Similarly situated people. Option D. Only corporations. The correct answer is option C. Similarly situated people. Equal protection asks whether the government treats similarly situated persons differently without sufficient justification. It is not limited to corporations, judges, or landlords. Question 44. Commercial speech receives First Amendment protection but may be regulated when it is what? Option A. About a lawful product. Option B. False or misleading. Option C. Printed in color. Option D. Spoken by a seller. The correct answer is option B. False or misleading. False or misleading commercial speech can be regulated more readily. Color printing, seller speech, and lawful product advertising do not automatically remove protection. Question 45. Police power allows states to regulate for health, safety, morals, and what? Option A. General welfare. Option B. Corporate dividends only. Option C. Federal treaties only. Option D. Private gossip only. The correct answer is option A. General welfare. State police power covers regulations for health, safety, morals, and general welfare. Dividends, treaties, and gossip do not define the police power. Question 46. Torts are civil wrongs that usually allow the injured party to seek what? Option A. A legislative seat. Option B. Automatic imprisonment of the defendant. Option C. A new constitution. Option D. Remedies such as damages. The correct answer is option D. Remedies such as damages. Tort law provides civil remedies such as damages for wrongfully caused harm. Legislative seats, automatic imprisonment, and new constitutions are not tort remedies. Question 47. Negligence requires duty, breach, causation, and what final element? Option A. Consideration. Option B. Venue. Option C. Damages. Option D. Trademark. The correct answer is option C. Damages. Negligence requires actual harm or damages along with duty, breach, and causation. Trademark is intellectual property, consideration is contract law, and venue is procedural. Question 48. Reasonable person analysis is most closely tied to which negligence element? Option A. Statutory supremacy. Option B. Breach of duty. Option C. Contract capacity. Option D. Agency ratification. The correct answer is option B. Breach of duty. The reasonable person standard helps decide whether the defendant breached a duty of care. Capacity, ratification, and supremacy are separate legal concepts. Question 49. Proximate cause limits liability to harms that are what? Option A. Foreseeable enough. Option B. Always intentional. Option C. Never monetary. Option D. Automatically criminal. The correct answer is option A. Foreseeable enough. Proximate cause limits liability to sufficiently foreseeable results of the conduct. It does not require intent, exclude money damages, or make every case criminal. Question 50. Strict liability can apply even without proof of what? Option A, product sale. Option B, injury. Option C, causation. Option D, fault. The correct answer is option D. Fault. Strict liability may impose responsibility without proving fault. A product or activity context, injury, and causation are still usually important to recovery. Question 51. Defamation involves a false statement that harms what? Option A, venue selection only. Option B, inventory counting only. Option C, reputation. Option D, contract formation only. The correct answer is option C. Reputation. Defamation protects reputation from false statements communicated to others. Contract formation, venue, and inventory are different areas of law or business operations. Question 52. Libel is defamation that is typically expressed in which form? Option A, contract assignment only. Option B, written or recorded form. Option C, pure silence only. Option D, physical trespass only. The correct answer is option B. Written or recorded form. Libel is generally written, printed, or otherwise fixed defamation. Silence, trespass, and assignment do not describe libel. Question 53. Slander is defamation that is typically communicated how? Option A, spoken orally. Option B, through land title. Option C, by product delivery. Option D, by patent registration. The correct answer is option A. Spoken orally. Slander is usually spoken defamation. Land title, delivery, and patent registration involve property or business processes rather than oral defamation. Question 54. Battery requires harmful or offensive contact plus what mental element? Option A, consideration. Option B, venue. Option C, ratification. Option D, intent. The correct answer is option D. Intent. Battery requires intentional harmful or offensive contact. Consideration belongs to contracts, venue concerns location, and ratification concerns approval of acts. Question 55. Assault protects against apprehension of what kind of contact? Option A, valid contract acceptance. Option B, product warranty repair. Option C, immediate harmful or offensive contact. Option D, future tax audit. The correct answer is option C. Immediate harmful or offensive contact. Assault involves reasonable apprehension of imminent harmful or offensive contact. A future audit, contract acceptance, or warranty repair is not assault. Question 56. Trespass to land occurs when someone intentionally enters land without what? Option A, a jury verdict. Option B, permission or legal right. Option C, a sales receipt. Option D, a corporation seal. The correct answer is option B, permission or legal right. Trespass to land involves unauthorized intentional entry onto another's property. Receipts, corporate seals, and jury verdicts are not the permission element. Question 57. Conversion is best described as serious interference with what? Option A, another person's personal property. Option B, a judge's calendar. Option C, a statute's title. Option D, a witness's oath. The correct answer is option A, another person's personal property. Conversion is substantial interference with another's personal property rights. Court calendars, statute titles, and witness oaths are not personal property interests. Question 58. Nuisance law usually concerns interference with the use or enjoyment of what? Option A, consideration. Option B, jury instructions. Option C, product packaging. Option D, property. The correct answer is option D, property. Nuisance involves unreasonable interference with property use or enjoyment. Consideration, jury instructions, and packaging are not the property interest protected by nuisance law. Question 59. Product liability claims often focus on defective design, manufacture, or what? Option A, pleadings. Option B, dividends. Option C, warnings. Option D, venue. The correct answer is option C, warnings. Product liability may arise from design defects, manufacturing defects, or inadequate warnings. Venue, pleadings, and dividends are not the defect categories. Question 60. Agency relationships are created when one person acts for another and is subject to what? Option A, permanent employment only. Option B, control. Option C, strict secrecy in all matters. Option D, automatic ownership. The correct answer is option B, control. Agency involves an agent acting on behalf of a principal and subject to the principal's control. It does not require secrecy, ownership, or permanent employment. Question 61. Principals are bound by contracts an agent makes within what kind of authority? Option A, actual or apparent authority. Option B, personal hobby authority. Option C, unknown criminal authority. Option D, random stranger authority. The correct answer is option A, actual or apparent authority. A principal can be bound when an agent acts with actual or apparent authority. Hobbies, unknown crimes, and random strangers do not create agency authority. Question 62. Actual authority is created by communications from whom to the agent? Option A, a newspaper reader. Option B, a competitor. Option C, a court clerk only. Option D, the principal. The correct answer is option D, the principal. Actual authority comes from the principal's manifestations to the agent. Newspaper readers, competitors, and clerks generally do not grant authority for the principal. Question 63. Apparent authority depends on what the principal causes a third party to believe about whom? Option A, the juror. Option B, the auditor. Option C, the agent. Option D, the judge. The correct answer is option C, the agent. Apparent authority arises from the principal's manifestations that lead a third party to believe the agent is authorized. Judges, jurors, and auditors are not the agent whose authority is at issue. Question 64. Ratification happens when a principal later does what to an unauthorized act? Option A, hides every record. Option B, approves it. Option C, criminally prosecutes it automatically. Option D, converts it into a statute. The correct answer is option B, approves it. Ratification occurs when the principal later accepts or approves an act done without authority. It is not automatic prosecution, statutory creation, or record hiding. Question 65. Fiduciary duty requires agents to act primarily for whose benefit? Option A, the principal. Option B, a rival business. Option C, a random customer. Option D, the local newspaper. The correct answer is option A, the principal. Agents owe fiduciary duties of loyalty and care to their principals. Rival businesses, random customers, and newspapers are not the primary beneficiaries of that agency duty. Question 66. Respondeat superior makes employers liable for employees' torts committed where? Option A, Only at home after midnight. Option B. Only during jury service. Option C. Only before hiring. Option D. Within the scope of employment. The correct answer is option D. Within the scope of employment. Respondeat superior can impose employer liability for employee torts within the scope of employment. Home conduct, jury service, and pre-hiring acts usually fall outside that scope. Question 67. Independent contractors differ from employees mainly because the hiring party controls what less directly? Option A. The court's jurisdiction. Option B. The existence of statutes. Option C. The manner and means of work. Option D. The law of gravity. The correct answer is option C. The manner and means of work. Independent contractor status often turns on less control over the manner and means of performance. Gravity, jurisdiction, and statutes are not controlled by the hiring party. Question 68. Employment at will generally allows either party to end employment when? Option A. Never without a governor's signature. Option B. At any time for lawful reasons. Option C. Only after a jury trial. Option D. Only when a contract is illegal. The correct answer is option B. At any time for lawful reasons. Employment at will permits termination by either side for any lawful reason or no reason, subject to exceptions. Jury trials, illegality, and governor's signatures are not general requirements. Question 69. Wrongful termination claims often arise when firing violates public policy or what? Option A. An employment contract. Option B. A customer preference. Option C. A competitor slogan. Option D. A product manual only. The correct answer is option A. An employment contract. Wrongful termination can involve violation of a contract, statute, or public policy exception. Customer preferences, slogans, and product manuals alone usually do not create the claim. Question 70. Discrimination law generally prohibits employment decisions based on protected what? Option A. Inventory levels. Option B. Contract prices only. Option C. Office furniture. Option D. Characteristics. The correct answer is option D. Characteristics. Employment discrimination laws protect people from decisions based on protected characteristics. Inventory, prices, and furniture are business considerations rather than protected categories. Question 71. Harassment becomes legally significant when it creates a hostile work environment or involves what? Option A. Routine product delivery. Option B. Valid invoice review. Option C. Quid pro quo pressure. Option D. Accurate timekeeping. The correct answer is option C. Quid pro quo pressure. Harassment law recognizes hostile environment and quid pro quo forms. Timekeeping, delivery, and invoice review are ordinary work activities unless tied to unlawful conduct. Question 72. Workers' compensation systems usually replace many workplace injury lawsuits with what? Option A. Federal treaties. Option B. Statutory benefits. Option C. Automatic criminal convictions. Option D. Unlimited punitive damages. The correct answer is option B. Statutory benefits. Workers' compensation provides statutory benefits for covered workplace injuries, often as an exclusive remedy. It does not create criminal convictions, unlimited punitive damages, or treaties. Question 73. UCC sales rules apply to movable goods rather than what? Option A. Real property. Option B. Consumer products. Option C. Inventory items. Option D. Office equipment. The correct answer is option A. Real property. Article 2 applies to goods, which are movable at the time of identification to the contract. Real property is land, while consumer products, inventory, and equipment can be goods. Question 74. Goods are identified to a contract when they are selected as what? Option A. The courthouse location. Option B. The buyer's legal lawyer. Option C. The seller's tax rate. Option D. The items to be delivered. The correct answer is option D. The items to be delivered. Identification means specific goods are designated as the goods under the contract. Courthouse location, legal counsel, and tax rates do not identify the goods. Question 75. Risk of loss rules decide who bears loss when goods are damaged before what? Option A. A jury is selected. Option B. A trademark is searched. Option C. Final delivery or acceptance. Option D. The Constitution is amended. The correct answer is option C. Final delivery or acceptance. Risk of loss rules allocate responsibility when goods are damaged before completion of delivery or acceptance. Constitutional amendments, jury selection, and trademark searches are unrelated. Question 76. Perfect tender under the UCC generally lets a buyer reject goods that fail how? Option A. Only if the price is high. Option B. In any respect to conform. Option C. Only by being late 10 years. Option D. Only after a felony. The correct answer is option B. In any respect to conform. The UCC perfect tender rule allows rejection when goods or delivery fail to conform in any respect, subject to exceptions. Extreme lateness, felonies, or high prices are not the only grounds. Question 77. Cure allows a seller to fix a defective tender under certain conditions before what? Option A. The contract deadline expires. Option B. The buyer writes a review. Option C. The judge chooses venue. Option D. The product is advertised. The correct answer is option A. The contract deadline expires. A seller may cure a non-conforming tender if time remains or other UCC conditions are met. Reviews, venue, and advertising are not the core timing rule for cure. Question 78. Express warranties are created by seller statements, samples, or what? Option A. Court pleadings only. Option B. Buyer silence always. Option C. Unrelated rumors. Option D. Descriptions of the goods. The correct answer is option D. Descriptions of the goods. Express warranties can arise from affirmations of fact, samples, models, or descriptions. Pleadings, buyer silence, and unrelated rumors do not normally create seller warranties. Question 79. Implied warranty of merchantability means goods are fit for what? Option A. Avoiding all taxes. Option B. Winning lawsuits. Option C. Ordinary purposes. Option D. Every unusual purpose. The correct answer is option C. Ordinary purposes. Merchantability requires goods to be fit for ordinary purposes and meet basic trade expectations. Unusual uses, tax avoidance, and litigation success are not the warranty standard. Question 80. Implied warranty of fitness for a particular purpose arises when the seller knows what? Option A. Only the local weather. Option B. The buyer's special purpose and reliance. Option C. Only the buyer's birthday. Option D. Only the court docket. The correct answer is option B. The buyer's special purpose and reliance. This warranty can arise when the seller knows the buyer's particular purpose and the buyer relies on the seller's skill or judgment. Birthdays, dockets, and weather are not enough. Question 81. Title passage concerns when ownership of goods moves from seller to whom? Option A, buyer. Option B, judge. Option C, witness. Option D, competitor. The correct answer is option A, buyer. Title passage concerns transfer of ownership from seller to buyer. Judges, witnesses, and competitors are not the ordinary transferees in a sale of goods. Question 82. Good faith purchasers may sometimes receive better rights than the seller had under what law? Option A, traffic law only. Option B, criminal sentencing only. Option C, divorce law only. Option D, UCC rules. The correct answer is option D, UCC rules. The UCC includes rules that can protect good faith purchasers in certain transactions. Traffic, sentencing, and divorce law are not the sales law source of that protection. Question 83. Negotiable instruments are written promises or orders to pay what? Option A, personal labor only. Option B, court testimony. Option C, money. Option D, real estate. The correct answer is option C, money. Negotiable instruments are commercial paper promising or ordering payment of money. Land, labor, and testimony do not satisfy the basic payment in money nature. Question 84. Checks are drafts drawn on which type of institution? Option A, warehouse. Option B, bank. Option C, restaurant. Option D, court. The correct answer is option B, bank. A check is a draft drawn on a bank and payable on demand. Restaurants, courts, and warehouses are not the drawee institution for checks. Question 85. Holder in due course status gives special protection against many what? Option A, personal defenses. Option B, all criminal laws. Option C, every tax rule. Option D, all future contracts. The correct answer is option A, personal defenses. A holder in due course can take free of many personal defenses. The status does not exempt someone from criminal laws, taxes, or every future contract obligation. Question 86. Secured transactions give creditors rights in collateral to support what? Option A, a jury instruction. Option B, a constitutional amendment. Option C, a product advertisement. Option D, payment or performance. The correct answer is option D, payment or performance. A secured transaction uses collateral to secure payment or performance of an obligation. Jury instructions, amendments, and ads are not the secured obligation. Question 87. Attachment of a security interest generally requires value, rights in collateral, and what? Option A, a newspaper announcement. Option B, a public parade. Option C, a security agreement or authenticated record. Option D, a criminal indictment. The correct answer is option C, a security agreement or authenticated record. Attachment usually requires value, debtor rights in collateral, and an agreement or authenticated record describing the collateral. Indictments, announcements, and parades do not attach security interests. Question 88. Perfection of a security interest often protects the creditor against whom? Option A, only court reporters. Option B, third parties. Option C, only the debtor's pets. Option D, only company slogans. The correct answer is option B, third parties. Perfection gives public notice and priority protection against third parties. Pets, slogans, and reporters are not the legal priority audience. Question 89. Bankruptcy provides debtors a legal process for dealing with what? Option A, debts. Option B, traffic routes. Option C, jury seating. Option D. Trademark fonts. The correct answer is option A. Debts. Bankruptcy law creates a process for handling debts and creditor claims. Traffic routes, jury seating, and trademark fonts are unrelated to bankruptcy's purpose. Question 90. Chapter 7 bankruptcy is most associated with what process? Option A. Corporate merger only. Option B. Patent licensing only. Option C. Criminal appeal. Option D. Liquidation. The correct answer is option D. Liquidation. Chapter 7 commonly involves liquidation of non-exempt assets and distribution to creditors. Mergers, patent licensing, and criminal appeals are different legal processes. Question 91. Chapter 11 bankruptcy is often used by businesses seeking what? Option A. Immediate criminal immunity. Option B. Automatic trademark ownership. Option C. Reorganization. Option D. Jury selection. The correct answer is option C. Reorganization. Chapter 11 is associated with reorganization, often allowing a business to continue operating under a plan. Jury selection, criminal immunity, and trademark ownership are not its main function. Question 92. Property law distinguishes real property from what other category? Option A. Agency authority. Option B. Personal property. Option C. Federal jurisdiction. Option D. Jury verdicts. The correct answer is option B. Personal property. Real property is land and things attached to land, while personal property covers movable or intangible property. Jurisdiction, verdicts, and agency authority are not property categories. Question 93. Intellectual property protects creations such as trademarks, copyrights, patents, and what? Option A. Trade secrets. Option B. Venue motions. Option C. Jury pools. Option D. Bankruptcy petitions. The correct answer is option A. Trade secrets. Trade secrets are a major form of intellectual property. Venue motions, jury pools, and bankruptcy petitions are procedural or insolvency concepts. Question 94. Trademarks primarily identify and distinguish the source of what? Option A. Court transcripts. Option B. Criminal sentences. Option C. Real estate deeds only. Option D. Goods or services. The correct answer is option D. Goods or services. Trademarks identify the source of goods or services and help prevent consumer confusion. Transcripts, sentences, and deeds are not the source identifying focus of trademarks. Question 95. Copyright protects original works of authorship fixed in what? Option A. A spoken rumor only. Option B. An unrecorded idea only. Option C. A tangible medium. Option D. A handshake only. The correct answer is option C. A tangible medium. Copyright protects original expression fixed in a tangible medium. Handshakes, rumors, and unfixed ideas are not protected as copyrightable fixed expression. Question 96. Patents generally protect useful inventions that meet novelty and what? Option A. Employment seniority. Option B. Non-obviousness. Option C. Venue preference. Option D. Consideration only. The correct answer is option B. Non-obviousness. Patentability typically requires novelty, usefulness, and non-obviousness. Venue, consideration, and seniority are not patentability requirements. Question 97. Trade secrets remain protected mainly by maintaining what? Option A. Confidentiality. Option B. Public disclosure. Option C. Courtroom seating. Option D. Consumer voting. The correct answer is option A. Confidentiality. Trade secret protection depends on the information being secret and reasonable efforts to keep it confidential. Public disclosure destroys secrecy, while seating and voting are unrelated. Question 98. Corporations are separate legal entities, meaning owners usually have what? Option A, unlimited personal liability for every debt. Option B, no ownership rights. Option C, automatic judicial power. Option D, limited liability. The correct answer is option D, limited liability. Corporate shareholders generally enjoy limited liability because the corporation is a separate legal person. Unlimited liability, no ownership rights, and judicial power do not describe ordinary corporate status. Question 99. Partnerships are usually formed when two or more people carry on as co-owners for what? Option A, court filing only. Option B, personal recreation only. Option C, profit. Option D, jury service. The correct answer is option C, profit. A partnership generally involves co-owners carrying on a business for profit. Jury service, mere filing, and recreation do not create the typical partnership relationship. Question 100. Limited liability companies combine liability protection with what common business advantage? Option A, mandatory public stock trading. Option B, flexible management and taxation options. Option C, automatic criminal immunity. Option D, no legal duties ever. The correct answer is option B, flexible management and taxation options. LLCs commonly offer limited liability along with flexible management and tax treatment. They do not provide criminal immunity, eliminate all duties, or require public stock trading.